Sh- Today, I'll be talking about the judgments of international trade law in respect of India. Srimati Gomti Mai versus State of Madhya Pradesh on 2nd April 2019. The Supreme Court in the case of Union of India and another was the International Trading Company and another held as under. What remains now to be considered is the effect of permission granted to the 32 vessels. As highlighted by our learned counsel for the appellant, even if it is accepted that there was any improper permission that may render such permissions vulnerable so far as the 32 vessels are concerned, but it cannot come to the aid of the respondent. It's not necessary to deal with the aspects because two parties cannot claim that since something wrong has been done in another case, direction should be given for doing another wrong. It would not be setting a wrong right, but it would be perpetuating another wrong. In the High Court of Madhya Pradesh, Srimati Gomtibai versus State of MP and others wrong. In such matters, there is no discrimination involved. The concept of equal treatment on the logic of Article 14 of the Constitution of India cannot be pressed into service in such cases. What the concept of equal treatment presupposes is existence of similar action and legal foothold. It doesn't countenance repetition of a wrong action to bring both wrongs on a par, even if hypothetically it is accepted that a wrong has been committed in some other cases, but introducing a concept of negative equality, the respondent cannot strengthen their case. They have to establish strength of their case on some other basis and not by claiming negative equality. The Supreme Court in the case of Doiwala Sehkari Shram Samvida Samiti versus State of Uttaranchal and others held as this court in the Union of India, this international trading company has held that two wrongs do not make one right. The appellant cannot claim that since something wrong has been done, in another case, direction should be given for doing anything wrong. It would not be setting a wrong side, but could not be perpetuating another wrong, and is in such a matter there is no discrimination involved. The concept of equal treatment on the logic of Article 14 cannot be pressed into service in such treatments. But the concept of equal treatment presupposes the existence of similar legal foothold. It doesn't countenance repetition of wrong action to bring wrong on a par. The affected parties have to create and establish strength of their case on some other basis and not by claiming negative quality. In view of the law laid down by this court in the above matter, the submissions of the appellant have no force. In case some of the persons have been granted permits wrongfully, the appellant cannot claim the benefit of the wrong done by the government. In Jalandhar Improvement Trust versus Sampurn Singh and the Union of India versus Rakesh Kumar, this court held that courts cannot issue a direction that the same mistake be perpetuated on the grounds of High Court of Madhya Pradesh, Srimati Gomati Bhai versus State of MP and others. Discrimination or hardship. Thank you.